Court does call the case. The People versus Kimberly Bombgardner.
Good morning, Your Honor. Chris Easthope appearing on behalf of and with Kimberly Bombgardner.
Your name?
Kimberly Bombgardner.
Oh.
Your Honor, we had today's time and date set for sentencing. We had a chance to fully review the pre-sentence report. There's no factual additions or corrections we would make to it. In terms of the fines and costs, my client would ask the court to consider giving her 90 days to pay it in full, or whatever. 90.
I misheard. Go ahead.
90. If the court would be willing to do that, she would have it paid in full. She is completed the victim's impact. She had a panel. She has one other meeting with the therapist tomorrow. Then she'll be done with that requirement. She's had no violations on her SoberLink. I think she'll be a good candidate for early entry of the probation program.
Did you?
Oh, Your Honor, Teresa Claire on behalf of probation. I just wanted to verify that Ms. Baumgartner did send me verification of her victim's impact panel and proof of her current treatment that she's in.
So she's done the victim's impact panel.
Correct, Your Honor.
All right. Got it. Ma'am, anything you want to say before I impose sentence?
No, other than I'm sorry.
All right. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of early intervention and continued abstinence from alcohol. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's a sentence of the court. You are placed on 12 months probation. You're to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $360 probation oversight fees. Do you have anything today?
Yes.
Okay. Follow-up question, how much?
I'll pay a third.
Okay, so no, Easthope knew that, so he should have done the math.
Pardon me.
I went to Western. We don't do
So
math.
the total is $1,450. So I'll put 500 down today.
If the court would
You
allow
made
that.
your client do the math.
She's better than me.
Okay. Pay 500 today, and then you needed about 90 days to get the balance paid.
Please.
Is that correct?
Yes.
And you pay it by the end of the year.
Yes.
All right. So the balance will be due by, I think, the 30th. What is my last business day? Balance will be due by December 31st, 2025. So if somebody says Happy New Year and you have paid.
It won't be a happy new year.
What'd you say?
I said then it won't be a happy.
Yeah, it really won't. So there's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete your early intervention programming with Anita Griffin. You're to provide proof of victims impact panel attendance to probation, which has been completed and provided. I'll continue the SoberLink for an additional 30 days in lieu of 4 days in jail. I'll order 180 days in jail. Credit 1, the balance is suspended.
Teresa Claire on behalf of probation. Your Honor, I made an error with my recommendation. This is a 93-day misdemeanor. So can you correct the jail time to 93 days, please?
93 days in jail, credit 1.
Thank you, Your
All
Honor.
right, thank you. Sir,
Oh,
you want more time?
no, it's a high DAC.
Oh, it is a high DC.
Yeah.
Your Honor, I'm sorry. Was corrected with, I was wrong with the impaired.
It was actually, she was
Because she pled to 2, count 2.
count to correct.
So it is
Right.
180.
It
Yes.
is a high DHC.
You were right the first.
I was right the first time.
There you
Sorry.
And I knew that, Miss Blair, because
My math wasn't so bad there.
that was, the only reason he should have said anything is because he was making up for that math. All right.
100%. Thank you, Your Honor.
Thank you, sir. Court does call the case of People versus Elizabeth Raget.
Good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Raget.
I'm Elizabeth Raget. Hi.
Go ahead.
Your Honor, we've reviewed the recommendation. We have no corrections to add to it. Libby is, it's been a journey to get here, but she's in a good place now. She's sober, she's feeling good, and she wants to continue that. So I ask the court to please adopt it.
All right. Ma'am, anything you want to tell the court before I
Just
impose?
thank you.
Pardon?
Thank you. Sometimes, yeah, I'm not gonna cry. And I'm sorry. I am.
Why are you sorry?
Because I affected a lot of people. Put my junk out there, so.
But up to this point, you've learned something about affecting people in that way.
I've learned a lot.
Tried to make yourself a better person, right?
Absolutely. That's why I said thank you.
What more can you expect from life, right?
I could have done better, but it's okay.
We all could at some point, right?
Yeah.
Okay. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of intensive outpatient treatment and individual therapy. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court that you are placed on probation for a period of 12 months. You're to pay $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, and $360 probation oversight fees. When can you pay that?
I'm looking for employment now. So, I mean, I have an interview later at 3. I'm doing everything I can. Can you give me 90 days?
In jail? No,
No.
that's a judge
I
joke. Don't worry about
did that, some of that. I'm good.
it.
As much time as you can give me, that would be nice.
So right now you're unemployed.
I am.
All right. What I'll do is I'll indicate a payment plan as arranged by probation.
Okay.
All right. So we'll try to get it paid off within that period in time. Once
Okay.
you're self-employed.
Okay.
There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete an IOP treatment or inpatient intensive outpatient treatment program, including all recommended aftercare with status reports to probation. You're to attend individual therapy with proof to probation. You're to provide proof of victims' impact panel attendance to probation. The scram tether will continue until there's proof of the intensive outpatient treatment. Until that's received by probation, you'll still be on the scram. I'll order 90 days in jail, credit 24. The balance is suspended.
Thank
All right.
you.
Thank you. Good luck. Court does call the case of the people versus Cedric Blair. No relation.
I'm here.
Assistant Public
I'm here, Your Honor.
Go ahead.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Blair, who appears via Zoom, Your Honor. Mr. Blair, could you please state your full name for the court?
Cedric Blair.
Thank you, Your Honor. Today's the date and time set for sentencing. Mr. Blair and I have had the opportunity to review the PSIR together, and we have no changes or corrections. And we would respectfully ask the court to adopt probation's recommendation. As to the fines and costs, Mr. Blair is asking if the court could consider giving him 2 months to pay that.
How much?
2 months, Your Honor.
2 whole months?
Or 3 if possible, make it a little easier.
Wow. Wow. No, it really wasn't going that way in my thought process. All right. Mr. Blair, anything you want to tell the court before I impose sentence?
Yeah, I am very regretful for my decisions that I've made. And since then, since the incident, I've actually gained employment at the University of Michigan, but I just started. So that's why I was asking for a little bit of time to pay the court costs and fines and whatnot. Because I literally, for me to have this job at U of M, it's kind of like a career move for me. So I don't want to prolong this situation any longer than it needs to be. So I will definitely put forth at maximum effort to make sure I get everything paid, or the fines and court costs paid as soon as possible.
All right. Sent to the court, you pay $480 fines and court costs. I'll make those payable by November 26, 2025. I'll order 93 days in jail, credit 5, balance is suspended. All right. Thank you, sir.
Thank you. Have a good day, Your Honor.
You do the same.
Thank you, Mr. Blair.
Thank you.
All right. Court calls the case, People versus James Herren.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Herren. Your Honor, I did attempt to get in contact with Mr. Herren. I don't see him present in the courtroom. Unfortunately, I was not successful in reaching him. I don't have an explanation for his failure to appear.
And you're aware that he has a violation report.
Yes, I did review that.
Blair.
Teresa Blair on behalf of probation. Your Honor, given Mr. Herren's violation report from Community Corrections and his failure to appear before this court today, probation is requesting that the court issue a bench warrant.
I would note that as of 2 days ago, when he was supposed to be taking a test at Community Corrections, that the defendant, Community Corrections, unlike counsel, was able to contact him. And he stated he couldn't be there because he had to work. So, not acceptable, but bench warrant will issue for defendant's failure to appear. Bond in this case will be set in the amount of $50,000. I'll give a 10% proof on that. That warrant will issue immediately. He got one last one.
Yes.
Court does call the case, People versus Christopher McKenzie.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. McKenzie, who's approaching. State your name for the record, please.
Christopher McKenzie.
All right, go ahead.
Your Honor, today is the date and time for sentencing. We did review probation's recommendation. We do ask that you adopt it, with the exception of paragraph or note 10. I'd ask the court to consider discontinuing the sober link today. He's been on it for 3 months. He has not had any positive tests. One of those months was also basically because of my fault for not getting the plea form into the court timely. So I will admit to my faults when necessary. So
How's that sword feel as he fell into your chest? Go ahead, I'm sorry.
it's just the fact. So he has been on it. I know take care. I know there has been some late tests. I've spoken with that regarding those with Mr. McKenzie at length. It's really, I know we talked about this at the last court days, really because of his work and the nature of being a nurse and I always get the words wrong, but pulmonary ICU.
Yes.
And he is kind of locked into a patient. He can't leave that patient. It's high stakes job. So that's the reason for the late test. We went through his work schedule together and looked at the days that they kind of correlate together. So that's my request for that. Regarding the assessment, we did also review that together. We disagree with a few things that are noted in the assessment. Specifically, the MAST score is based on some things that Mr. McKenzie and I were concerned about. One, because he has a step cousin that is an alcoholic and now sober. She said that he scored a point because of that. Not a blood cousin. He's married into the family. We disagree with him getting a point because of that. And also the BAC at the time of the offense was a 0.18, and she disagreed with that. I will say Mr. McKenzie's been
You said she disagreed with that.
with to be clear, how much he consumed and what his BAC was at at the scene.
She disagreed with that as opposed to,
So he said he represented that he drank a certain amount of beers. Her representation is that he must have drinking more.
because of the BAC.
Because of the BAC. And that his tolerance was higher because of that. But as is described in the assessment, Mr. McKenzie rarely drinks. He doesn't really have a tolerance. And I think that's kind of what led to this incident. And I will say overall, Your Honor, it's been a pleasure to work with Mr. McKenzie. He's been very honest, very forthcoming with me throughout this entire process. He wants to take responsibility.
Is that, like, different from your other clients?
You know,
Never mind.
every
Oh,
client's
no,
different, Your Honor.
do not answer that. You're just gonna get in trouble. I was baiting you. Go ahead.
But he wants to take responsibility for his actions, and he was really, I mean, from the first time we talked, he was ready to do so. So I just hope the court takes that all into consideration when sentencing him today.
Sir, is there anything you want to say before I impose sentence?
I just wanted to say that I think you do a great job, Your Honor. This is not fluff. I typically don't see judges be so harsh with the people today, and I feel like they should be. In the world that I grew up in, courts were something to be feared and respected, of course. And you bring that to the table, and you also bring compassion. I greatly appreciate that. Also, at the same time, I did want to take responsibility for my actions right away, as she had stated. I made a mistake that night in leaving. I had all the right intentions of staying, and I brought all the right things, like I packed a bag, I brought my dog, I brought pillows and a blanket. I made a mistake in leaving, and I accept responsibility for my actions. I should have never left, and that's what brought me here today. And I wanted the court to know that.
Thank you for those kind words, sir.
It's what we do as nurses.
Yes, you do, amongst other things.
Lots of other things.
Kind of makes my job pale in comparison.
Not at all.
Ms. Perry, you said you went through, we sent an order for compliance with community corrections, and I know we had addressed this at an earlier date, or we talked about it at least at an earlier date. Did you supply that scheduling to Ms. Blair?
Not Ms. Blair. I did to Mr. Siller because the initial violation report, or I think they considered a progress report,
Right.
came out before the plea. I did sit down with Mr. Siller and go through the dates, and he, we reviewed that together, but I had not provided that to Ms. Blair.
Okay, because this is an unusual circumstance. I get the employment issue. What I'm not clear of is whether or not it coincides with the
newest one
test, because theoretically, well, not theoretically, actually, by the programming rules, the very fact that he didn't take some of these tests means, first of all, it could have been a violation, right? But also that it effectively means he hasn't been in compliance with it. So for me, just on that, to sort of take him off and relieve him of it, that could become an issue of something completely different for what I do typically on the program. But I realize this is a different circumstance. Yes, sir.
Yeah, there was one day I did leave it in my car. I work at the University of Michigan, and if you're aware, there's no going back to your car. You park far away, and you have to get on a bus. The buses don't ride during the day. It would take me an hour to get to my car and back. So the one day where I didn't do them at all, that was that. And that was why when I got back to my car, I immediately did one. And that was definitely my own fault. But otherwise, yeah, it's a workday schedule thing. And sometimes I'm stuck in and I don't get the ability to leave.
He's so honest.
He is. I think, and also there's like another day that you were working 12 days and then tested late because you were sleeping I think you tested at 9.
I did.
A little after 9. And
with that being said, they all have been negative and will continue to be.
Yeah, but he, I think Mr. McKenzie he really doesn't want to scram tether also. So I just, he really doesn't want to scram tether because of his work. So I did want to note that for the record.
And again, I think we discussed that at the last time that it
Yeah.
wasn't gonna do that unless absolutely necessary.
Yeah.
Um,
So he, just for the record, he'd rather stick with SoberLink if the court's considering, all the options available to this court. But knowing that I think we just both want the court to know he's really trying his best. It's just the nature of his work, just like when I'm here stuck with you.
Oh, stop.
What?
I know stuck was probably poor choice of words.
I'm getting a little poke,
No.
jab, jab.
Apparently, I need you to explain that. What do you mean?
Listen, sometimes I gotta go to the bathroom, but I'm on the record. I can't.
Hey, that does happen to me too. You can't leave.
Sometimes I'm stuck here with you. We can
That was
solve
poor
that problem.
I'm enjoying my time so much with you, Your Honor, but
Except now she's trying to spin it.
She's learning a lot.
Okay. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of early intervention, education, attendance at AA meetings, and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. It's therefore the sentence of the court. I'll place you on probation for a period of 12 months. Pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $360 probation oversight fees. When do you think you can get that paid?
Would you be kind enough to give me the same as the lady that was here before by the end of the year?
Nurses get paid a lot of money. I know. They
We get paid.
They make a boatload.
I don't know about all
they
that.
probably need more, to be honest. They probably need more, given all that they put up with.
That's what I'm saying.
I am a new nurse. So I don't get the big pay yet. And it's Christmas coming soon. I'm a single dad.
Do you have anything today? So
Yeah. Yes, absolutely. I could pay $400 today.
not even what the other lady did.
Now you put me on.
All right. $400 today.
Yes, sir.
Pay the balance by November 26th.
That works for me. Thanks.
I'm gonna go back out. I gotta stop being so nice. Get back on my normal routine. That Miss Parody apparently. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety program. You're to attend 2A meetings per week with monthly verification to probation. You're to provide proof of victims impact panel attendance. With reference to the SoberLink, what I will do is I'll order that it will continue for an additional 30 days in lieu of 5 days in jail. However, given the circumstances in this case, Ms. Perrin, if you provide some type of breakdown that these missed tests were related to his work as a pulmonary care nurse, then I'll leave it in the hands of probation. If you turn that over to probation, if probation sees that that is indeed the case, then the SoberLink can discontinue.
Okay,
Fair
fair enough.
And I'll order 93 days in jail that is suspended.
Thank you.
Thank you, sir.
Thank you,
Have a
Your
blessed
Honor.
You do the same.
No, my license is for.
You need to. Okay, we're good.
All right, yes, sir.
Okay, sir, is there anything you want to tell me before I impose that?
Yes, sir. I realized I was on a good path over the last decade. I was about to go in front of the governor to get my record expunged, and this happened 2 days prior, and it just I made an ignorant choice, and it affected my mother and my son. Stressing my mom out, my son asking about the teller on my leg, and I just want to apologize to the court and my family, and I'm definitely gonna do better, and I'm not gonna make no more ignorant choices like that, sir.
How old's your child?
9,
Boy, girl?
boy.
Then you have to do better.
Yes, sir.
You said your mother knew.
Yes, it's just,
What did she say?
boy, what is you doing? It's driving me crazy. You know, she wanted to come to court today, but I was like, Mom, I did this. I don't want to stress you out even more.
So you didn't want your mom to come to court?
I mean, she live in Bromley. She bad driving on the expressway. It's raining, you know. I didn't, and I know. I figured I was going to
you know
jail.
what? So
I just,
I'm gonna tell you what. For as long as she graces the planet, if your mother wants to come someplace where you might be in trouble,
yes, sir.
you should bring your mother.
Yes, sir.
So I realize people make mistakes. I'm not mad at you for anything other than that you broke your brother's heart. And that you didn't let her come down here. Because she probably had some stuff to tell me.
Yes, sir.
And you just didn't want me to hear that. So I probably should lock you up for the whole boat because you didn't bring your mom. I know what I can do.
I
I
apologize.
can lock you up, and the only person that you can be released to is your mother. Is she that bad a driver?
I mean, well, she used to work at Milan, so I mean, she's familiar with the area. But you know, as she's 71 years old, I just didn't want. It was my mistake.
She's a spry 71-year-old that still drives, right?
Yes, sir.
All right. Okay. Anything else you want to tell me?
No, sir.
You probably should have told me all that, right?
Yes, sir.
The court acknowledges this is not a serious misdemeanor as defined by statute. However, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient programming. The court will therefore follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, to monitor compliance, and recommended treatment. We'll place you on probation for a period of 24 months. You're to pay $1,255 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When can you get that paid?
I can pay half today, Your Honor.
Do you have a total, Ms. Blair? Everybody's like doing fractions. I'm not in the mood.
I think it's about 3,500.
I have to start putting total.
Yeah, I know. How much do you have to pay?
What was the total amount, Your Honor? I'm sorry.
He didn't bring his mother. He's making me do math.
2175.
I'll pay it all today, Your Honor. Get it out the way. That way, Christmas coming up, I can get. I need to. I'll take care of it today.
So he had us go through all that.
I'm sorry.
And he had the money to pay.
I apologize.
Mr. Long, you need no, never mind. All right, today.
One more
Thank
thing,
you.
Your Honor. Is there anything, a court order that we could have to clear his 625G hold?
I think that clears at some point once he's done here. I think something happens with his license. I don't know what sanctions they may impose otherwise.
Thank you.
All right. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to provide proof of an intensive outpatient program completion, including all aftercare recommendations. Complete current individual therapy with probation. Attend 2A meetings per week with monthly verification to probation. I will discontinue the scram tether. In accordance with statute, I'll order 365 days in jail credit for the 4 days that you served. I will remand the defendant to serve the additional 1 day, then the balance will be suspended. Defendant is remanded.
Thank you, Your Honor.
Court does call the case of the people versus Vincent D. Good morning.
Good morning. Good morning. Yeah. Good to see you too. Yeah.
Wow. All right. Yes, you know that. All right, Mr. Bird, do you have a client?
Unfortunately, no, Your Honor. I did try and call him at his last working number. Madam Clerk did inform me that he was trying to contact the clerks earlier this morning, but unfortunately, he's not here.
I'll tell you what I'm gonna do, Mr. Bird, because I'm going to adjourn this. Given the nature of the sentence, I'm not gonna French one. And that there's been some contact, I'll just adjourn this out to our next day. I'll adjourn this to October 8th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome.
Your Honor.
Say I didn't do anything nice.
Never again, Your Honor.
All right.
You and Your Honor, go have a great day.
You do the same, sir.
All right.
Court calls the case People versus Kyle Beckerman. Go ahead, Mr. Burgess.
Good, thank you, Your Honor. Good morning. May it please this honorable court, David Burgess on behalf of Kyle Beckerman. Judge, apologize, I had a logistical issue this morning with my associate, so.
That's fine. Your name, sir?
My name's Kyle Beckerman.
All right. Go ahead, sir. This is a date and time set for sentencing.
Your Honor, I've reviewed the pre-sentence report. It is accurate. Understand that the recommendation was for a year in the county. Based on the charge, it was a misdemeanor plea to use of cocaine, Your Honor. And last time we were in court, we were trying to get my client into inpatient treatment. And I believe the court allowed him to be referred, but I'm asking the court to consider either releasing him to treatment or giving him a time served sentence, Judge. I know he doesn't have any means right now. He's homeless. This is somewhat of a victimless crime, Judge. So I'm asking the court to consider a time served sentence or at least release him to an inpatient treatment so that he can get some help for the issue, the substance abuse issues.
Mr. Blair.
Yes, Teresa Blair on behalf of probation. Your Honor, if the court is to consider a release to treatment, then probation would obviously have a different recommendation. There would be probation, a probation term that is recommended. So that could be monitored. When I met with Mr. Beckerman at the jail, he's very adamant with me that he would not comply with terms of probation. Therefore, probation did recommend the
Got it. Okay. That's why this sentence is structured in the way. It was based upon the defendant's comments.
Okay, I understand, Your Honor.
All right. Mr. Beckerman, anything you want to say before I close sentence?
I just wanted to apologize to the people, the court. Right now I can't do probation. I'm homeless. I have no income. I really have nowhere to go when I get out, so I don't want to waste the court's time. But I just wanted to apologize to the court and people.
Sentence of the court, $125 statutory fine, 365 days in jail, credit 51, defendant to serve the balance. Thank you.
Yeah.
Thank you.
Thank you. Court calls the case, People versus Christopher Fair.
Under Natalie Pate on behalf of, but I do not speak with Mr. Fair, Your Honor. Today time set for a violation of probation. He is released from custody, and Mr. Fair and I did speak on the phone yesterday. I do not have an explanation for this hearing.
Teresa Blair on behalf of probation. Your Honor, given that Mr. Fair is scheduled before the court for a violation of probation, he's had multiple failure to appears in the past. And his presence not here today. Probation is requesting a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. I'll give a 10% privilege on that. That warrant issues immediate. Court does call the case, People versus Justin Duffany.
Your Honor, for the record, Walter White with it on behalf of Mr. Duffany. Good morning.
Good morning.
He and I have had a chance to discuss the pre-sentence report and its recommendations. I don't have any factual corrections to make to the report. A couple of observations. If you look at his criminal history, it looks long and extensive, but if you look at the dates, you realize that except for a traffic ticket last year, his last offense was 12 years ago, excuse me. Since he's been in jail, he has used the time productively. He's gotten into the Dawn Farms program and also AA on his own initiative. I would ask the court to consider releasing him today and requiring him to find a treatment program. The recommendation is to complete the Dawn Farms program, and I believe that would take him another 3 weeks. But if he could be released today and told to go to another program, I'd appreciate it. I'm sure he would.
Is there anything you want to tell me before I impose sentence?
I just want to apologize for my actions with the bond and that I know that I screwed up. My priorities are in the wrong place. I have taken this time with that trustee and I've been trying to help and better myself. And I promise you I won't be back in here.
Your Honor, if I could just add one more thing. He did have a prison sentence back in the 10, 12 years ago. After he got out in 2017, he completed probation, never tested dirty. So it's not like he's incapable of behaving when it comes to drugs and alcohol. And I just wanted to bring the court's attention to that.
Sentence of the court, 24 months probation. You're to pay $655 fine, court costs, $120 probation oversight fees. That'd be a probation payment plan that's paid by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Indale Dawn Farm program, including all recommended aftercare. You're to attend 2 AANA meetings per week with verification to probation. You're to maintain employment with proof to probation. You're to contact probation within 24 hours of your release from custody and then report as directed. I'm going to follow, I understand what you're saying, Mr. White, but I'm going to follow what probation is indicating. I want him to be able to get a good start because I think he can do it. I'm not really doubting that. He just needs the support around him to get him through.
Thank you, Your Honor.
I think Dawn Farms will do that for him. So I'm going to order 365 days in jail, credit 57 days that he served. He's to remain in custody, complete the Dawn Farm program, and then he will be released, and then the balance will be suspended. Okay, let's get that start for you. What I'm trying to do.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Vincent Lambert.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Lambert. Mr. Lambert was transferred from the Washtenaw County Jail to Wayne County Jail. I could not confirm that he is still there, but that is what the jail told me when I went to see him.
Transferred from our jail to Wayne.
Yes.
So you don't know what to do with the case. You're just stuck with me here.
I'm just stuck with you. And without a client. So I'd asked for an adjournment to see if I can hunt him down. If he's still in Wayne County, obviously I'd contact the people to see if we can get a writ. If not, I'll try to get him here, but I haven't been able to have contact with him.
Given the nature of the sentence and what you're indicating, I'll adjourn it out. I won't issue a bench warrant to October 8th, 2025, 9 a.m. Court does call the case of the People versus Sean Costello.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Costello, who stands directly. State name for the record, sir.
Sean Costello.
Thank you, Your Honor. It's my understanding that this is a show cause on the unpaid fines and costs on a closed case, Your Honor.
Is that what this is set for? It is.
So, Your Honor, unfortunately, it was after I left the jail yesterday that I discovered that Mr. Costello was in custody. It is my understanding he's being held on some other misdemeanor cases with his next court date being October 9th. Given he's being held on those matters and I cannot make payments on the show cause in this closed case, I'd be asking for an adjournment of the show cause, please, Your Honor.
What he's being held on right now are all misdemeanors?
I believe that's what they were when I looked, Your Honor. Yes.
Give me November day. We'll see. All right. I'll adjourn this to November 12th, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you. Court does call the case of People versus Terrence Powell.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Powell. I don't see Mr. Powell here, Your Honor. I did speak with him. He said he has transportation issues. He couldn't get here in person, because it is a VOP. Obviously the Zoom request was rejected. So that is my only, explanation for his failure to appear. He would like to request an adjournment, so he can get here in person.
And Teresa Claire on behalf of probation, Your Honor, given that it was scheduled for a violation of probation, he is not compliant with his probation terms and he is not present. Probation is requesting a bench warrant.
Bench warrant will issue bond 25,000, 10% privilege. That warrant will issue immediately. Court does call the case of People versus Brian Gerard, all 4 cases.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Gerard. State your name for the record, please.
Brian Gerard.
Thank you.
Your Honor, these are show causes for money owed. Mr. Gerard has been in custody for almost, I think, 200 days at this point.
Gonna be for another 180 days.
His estimated release date in next jail is February. I think February 6th or 8th.
That's my out date.
I think so.
Oh, that's great.
It's February 26th.
I think, I can't remember exact, it's February. I can't remember if it was the 6th or the 8th of February. I think.
That's 2026.
Exactly, yes.
What's my last date this year?
Can I just pay? Can I just stay here? Just let him pay?
You mean like get
December 22nd.
Yeah.
So here's what I'm gonna do. I'm gonna adjourn all of these to December 22nd, 2025 at 9 a.m. And Ms. Perrine, what I would suggest that you do is to file the paperwork regarding these fines and costs. It's
Okay.
Gonna be there's not gonna be necessarily a reason to keep bringing him back.
Okay.
All right.
Thank you.
Thank you, sir. Court does call the case of the People versus Ahmed Dicko.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Dicko. Go state your name for the record, please.
There he is. Got it.
Ahmed Dicko.
Your Honor, this is a show cause. Mr. Dicko has a balance, I think, around $1,200. I would ask.
I have it at 1443.
Okay. Well, worse, but I would ask Mr. Dicko to advise the court what he can pay moving forward, please.
15, same amount.
Say that again, sir.
$15, same amount.
$15?
Yeah,
Why can you only pay $15?
because I'm currently unemployed. I've just
You're
been,
currently,
yeah. Can you hear me?
I can hear you. All right, what I'm gonna do is I'm gonna order $25 per month beginning October 1st. I'll set a review of his payment. What was my December day?
December 22nd.
Review of payment December 22nd, 2025 at 9 a.m. And his employment should have improved by that point. I expect payments. Thank you.
Thank you.
Court calls case People versus Nicole McCauley. Both cases.
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. McCauley. Ms. McCauley, please say your name for the record.
Nicole McCauley.
Your Honor, we did review the pre-sentence report. We don't have any material changes, additions, or deletions, and we do ask that you adopt the probation's recommendation.
Anything you want to tell me before I impose that?
I apologize about wasting your time.
You're not wasting my time. I get paid. All right. In case ending in 0597, sentence of the court, $125 statutory fee, $1,750 restitution to JSG payable through the court. I'll order 365 days in jail, credit the 272 you served. The balance is suspended on that case. I'm presuming that after these cases, she's not going to be released.
Yes, these are the last things holding her.
Ah.
She's on probation in Wayne County.
Got
She's
it.
been on a writ here, but she's been in custody for quite some time. She was in Wayne County, then Oakland County, I think back to Wayne County, then here.
Yeah.
So she's not working, so she's gonna need some time to,
Yeah, the 1750, I'll just make due and payable by December 31st, 2025. And so let her get out, get settled, and then try to make sure to try to arrange something regarding that. On the other matter, the case ending in 0111, on count one, the larceny, less than 200, I'll under $125 statutory fee, 93 days in jail, credit 93 served. On the count two, 200, larceny 200 to 1,000, $50 statutory fee. I'll reserve restitution for a period of 60 days. 300, and I'll order 365 days in jail, credit 272. The balance is suspended.
thank you.
All right, thank you. Court calls the case People versus Michael Kyle.
Under Natalie Pate for Mr. Kyle, who may be present via Zoom.
Michael Kyle.
Your Honor, I believe this was today set for state review, but I believe it was a show cause. I believe his balance is $360. The numbers I did have for him, unfortunately, are all now disconnected. I did send an email to the last email address I had for him, but other than that, I don't have further explanation for his failure to appear for the record request and adjournments.
Bench warrant will issue, bond 5,000, 10% privilege. Warrant will issue immediately. Court does call the case of the People versus Michael Patterson.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Patterson. Please state your name for the record, sir.
Michael Lee Patterson.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Patterson, and we do not have any material changes or corrections. I've also had the opportunity to review the recommendation for sentencing with Mr. Patterson. And although we do understand that Mr. Patterson is asking that he be released today and be sentenced to credit for time served, he states that he does reside at the Delana Center, and he is asking if Your Honor would allow him to be released today to go reside back at the Delana Center. Other than that, we would ask the court to adopt probation's recommendation.
Sir, anything you want to say before I impose sentence?
No, Your Honor.
On count one, indecent exposure, $125 statutory fee. Defendant is to submit a DNA sample. I'll order 365 days in jail. Credit 194 days served. Defendant is to serve the balance. On the count two, indecent exposure, $50 statutory fee, 365 days in jail. Credit 194 days served. Defendant is to serve the balance. Thank you. Court calls the case People versus Francis McMullen.
Teresa Claire on behalf of probation. Your Honor, Ms. McMullen was scheduled before the court today for a hearing on a prosecutor deferred sentence. She did complete all terms ordered by the court, and I did waive her appearance. Probation's recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with improvement.
Hearing no objection, so ordered. Court calls case People versus Javier Ruda.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ruda, who stands to my right. Please state your name for the record, sir.
Javier Ruda.
Thank you, Your Honor. It's my understanding this is set for a show cause hearing, and it's my understanding there is still a balance. Mr. Ruda is being held on other matters. He has a preliminary exam scheduled for the 30th of this month. I'm asking for an adjournment of the show cause of this case, Your Honor.
I'll adjourn this to November 12, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Jerron Wilson.
Oh.
Pardon? Unless I'm seeing.
Oh, I'm sorry. Good morning, Assistant Public Defender Laura Herren on behalf of Mr. Juan Wilson, who's here for the waive.
Claire, on behalf of probation, Your Honor, Mr. Wilson was scheduled for the court for a review hearing on a prosecutor deferred. He is compliant with all terms ordered by the court. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with.
No objection.
So ordered. Court does call the case of people versus Elizabeth Wilson.
Good morning, Your Honor. Ashley Wandy Feldes for the people.
Good morning, Your Honor. Attorney Michael Kelly, 77187 on behalf of Ms. Wilson.
Your name, ma'am?
Elizabeth Wilson.
All right. Date and time that the court had set for a restitution hearing at the request of the defense. I also have a motion to withdraw, which seems rather weird to me. So, wherever you'd like to start.
Your Honor, just in terms of the motion with withdraw, I did submit that request in advance, hoping that we would have the opportunity to be heard on that prior to today's hearing, not to cause any prejudice to my client. I am here, Your Honor, for today. I think it's the most efficient use of my time that I'm going to stay on with Ms. Wilson for purpose of the restitution hearing, since I'm already here.
Well, just so that we're very clear, and the reason the court did not sign the order is because the restitution hearing, particularly at your request, is part of sentencing. And I would not permit counsel to withdraw in the midst of sentencing. It just would not happen. So it's good that I don't have to deny the motion, but I wasn't signing it, but all right. So it's withdrawn. What are we doing with regard to the restitution? My understanding, the victim is here via Zoom.
She is here, Your Honor. I wasn't sure. Thank you, Your Honor.
Well, that's what I think I was informed of that. Ma'am, are you here?
Oh, yes, I am.
Okay, there you are. Okay. Thank you very much. All right, What are we doing?
Your Honor, has the court also received the estimate that was provided by Michelle Miller reference from Great Lakes Village and Frame for the repairs?
The one that is 3,200 2,029.08.
That is correct, Your Honor.
Yeah, I do that.
So, Your Honor, we could proceed to the hearing. I'm not sure if defense counsel, now that Ms. Miller is here, is willing to stipulate to the rest of the matter, if we do need to have a hearing.
We're here for the hearing, Your Honor.
Your Honor, will the court allow Ms. Miller to testify via Zoom?
That is how she's appearing. So yes, I will.
Miller, are you able to testify right now, or are you busy with something else?
I'm working.
Okay. Is there a point, Miss Miller, that you're going to have a break or a point where you can answer?
In about an hour and a half. In about an hour and a half. In about an hour and a half, I'll be done with this head, and I'll have this client under the dryer.
Got it. And then you'll be able to take some time and testify?
Yes, sir.
Okay. Then what I'm going to do, says about an hour and a half. What is it?
Oh,
1:30. All right, because her testimony is needed.
Can we have just a moment to confer with defense counsel to see if that's gonna work?
Yeah, Your Honor, I didn't block off a whole day for.
Well, counsel, you're in this case. Whether you blocked off a whole day or not, is irrelevant to me.
I'm in this case because you wouldn't sign the consent order for me.
Because it's inappropriate. It is inappropriate to ask to withdraw in the midst of sentencing.
It's not.
You have no authority. Do not interrupt me. You have no authority to show that that is appropriate.
Well,
it will be denied. Don't do that, counsel, because you don't want to go there with me. Not today.
Judge, I am being respectful as possible.
Court recalls the case, people, State of Michigan versus Elizabeth Wilson.
Right.
Good afternoon, Your Honor. Shalani calls for people.
Good afternoon, Your Honor. Michael Kelly, P 77187 on behalf of Ms. Wilson, who's present, standing to my right.
Elizabeth Wilson.
All right, what are we doing?
Your Honor, at this time, I believe my client is prepared to stipulate to pay the restitution.
Your Honor, do I have to pay the full amount?
I'm sorry, go ahead. Well, hang on a second. All right, here's what I'm gonna do, and then I'll answer your question. Okay. I'll order restitution in the amount of $3,029.08. Okay. And then my next, when you say, do you have to pay the whole amount? What are you asking me, ma'am?
Well, I've been advised that this is not a trial and I need to get my paperwork, please.
Okay, go ahead.
Due to the fact that I'm the only person that was there, she was driving a Cadillac. She wasn't driving the vehicle that has been stated in the police report. Also, she did not wait for the officer to show up so the officer could look at her vehicle. Anything could have happened to her vehicle from the time that she left Wendy's and from the time she got home. And then I didn't receive a phone call from the officer till 4 or 5 hours later, stating the fact that that this had happened. And all she had to do was send pictures over. And that justified the fact that I hit her car when I didn't. I would have stayed if I hit her car. It's what car insurance is for.
Hold on a second, ma'am. Okay, can we? Go ahead.
Sitting on the drive-through, there's just no way I could have done that kind of damage. You're sitting still. It would have affected.
Ma'am, let me just stop you. And I know you got something you want to tell me. But there was, but I read it. There was a no contest plea to these charges.
Right.
And now you're disputing them?
I took that because I was not informed that I had to pay restitution. I took that because that was the cheapest way out.
So, okay. Go ahead.
That's okay. Thank you very much for your time.
Is there anything else? I mean,
there's no proof of anything and it doesn't make sense to me. It really doesn't. I mean, the officer wouldn't look at my vehicle. I offered to bring it in, like I've been cooperative.
Right. Well, but understand that the only thing that I'm going to know when I'm looking at this, because it was a no contest plea, is what's contained in the report. And as part of a no contest plea, I accept what's in the report is true in terms of making a finding. Now, where you got the information that restitution may not happen, I don't know, and I'm not getting into that. I will just say that when something like this happens, the issue of restitution, a lot of it is statutory, it just occurs, okay? So going back to your initial question of the payment of the restitution. Now, how can you pay that? Let me ask you that first.
I can't. I don't have a job. But, it's the law. I've always followed the law, never been in trouble with the law. So, I mean, I just thought maybe you would take in consideration the fact that there's no proof. I mean, she just sends pictures over.
Okay. So here's the thing that you have to understand about this, and that's why I keep going back to the no contest plea. Once you enter that plea, then Miss Miller basically becomes a crime victim. And pursuant to the statutes, then she's entitled to restitution. That's a simplified version. Okay. So in essence, she's entitled to be made whole. Yeah. In terms of restitution, and now that it's been stipulated to, I don't know that there's much the court could do. Now, it really becomes an issue of how it gets paid. And it's also so that you know, because I know you've been in the courtroom with other cases, I'll try to work with people, but I have less flexibility with the issue of restitution. In fact, in a lot of ways, I have none. I can set it up so that it's paid over time, certainly, but I can't waive any part of it. My hands are tied in that respect.
So I needed to go to court and prove all that stuff in
Pardon?
order to avoid paying this then, right? That's what I needed to have done. Going to trial.
Ma'am, I can't answer that.
I know, I'm
Because-
sorry, I'm not getting
because
any
there-
answers, so I'm
because-
coming to you.
So, well, because there are so many, the reason I can't answer it is because there are so many reasons why somebody may not go to trial or goes to trial. There are a whole lot of different considerations that play into that. So if it were a simple yes or no, and I had an opinion about it, then I'd tell you, but I can't, in all honesty, say that.
Okay.
Okay.
Well, thank you for listening.
Not a problem. So in regard to the restitution, do you know how you're gonna get that paid or how you're gonna pay it?
I'll figure it out.
Okay, so, but I got you. But I need to sort of put something on it to say how you're going to do it.
It's $50 a month, according to my probation right now.
Pardon?
$50 a month.
$50 a month is what your payment plan is to us.
Yes.
Your Honor, that's for the fines and costs.
Fines and costs. All right, why don't we do it this way? Because you say you're not working.
No, I have a job, but I just applied for it and it takes another month to see if I get it, so.
Got it, okay. So, Ms. Blair, why don't we do this? Have you made any of the $50 payments yet?
Yes, I've already made 125.
That was on
Another
the
50.
date of sentencing, right?
Right.
Okay. And then, so then your next payment was gonna be the 50.
Right. I'll make that today when I leave.
Okay. Are you making that in cash?
No.
Okay, so here's what I'm gonna do. Let's set. You have her review is February 24th of 2027. All right, so here's what I want. The $50, so you'll need to pay it in cash, right?
Like come in here and actually pay
And
it?
actually pay it.
Okay.
The reason I'm gonna do, you have to do that is because I'm gonna have what you can pay in terms of the $50 go to the restitution.
Oh, okay.
Okay, but I can't do, if you were gonna pay it on a card, I can't do it that way.
Okay.
Okay, so it's gotta be cash that you come in and pay.
Okay.
All right, so I realize you set up a payment plan. She's now got this balance. It's gonna be $50 per month until probation tells you otherwise. If you get employed, then it might be something else.
Okay.
Got it?
Yep.
And you just have to pay that in cash. It's to go to the restitution and then be paid over so that balance can go down. Makes some sense to you?
Yes.
All right. And then we'll do it that way. So I've ordered it. It's payable through the court in accordance with what I've said and at the direction of probation.
Okay.
All right? Thank you.
And Your Honor, lastly, I just want to make sure that my appearance is being removed as attorney of record from this point forward.
File an order requesting that you be removed as attorney of record as one would do at the conclusion of a certain point, and the court will sign it. Thank you.
Thank you.
What is that?
12 o'clock. Technically, it's only 10 cases.
Why is Paige looking at me that way?
10 cases.
She's ready to go.
They're all show causes.
They're all show causes.
Yeah. So I
Okay,
thought
let's
it was
just,
on a roll.
let's just do it. Court does call the case of the people versus Ashley Beaupre.
On behalf of Ms. Beaupre, who should be present via Zoom.
She
Ma'am,
is, I think.
can you please state your name for the court?
Ashley Beaupre.
Okay.
Your Honor, this attorney spoke to Ms. Beaupre. It is my understanding that she is requesting a $50 a month payment plan. She would be able to pay more if possible. She is now back to work, going to school and working on getting her license, so she's asking for a $50 monthly payment plan.
Driver's license?
I think so. That's
Okay.
not specified in the note.
All right. And Ms. Beaupre, when would you like to begin those payments?
I can start this week.
All right, well, why don't we do it this way, give you a little bit of a breather. $50 per month beginning October 1st, okay? Not
Sounds
much of
good.
one. All right. And then $50 per month thereafter until it's paid. All right, ma'am, thank you.
Good to see you.
Good to see you too. You're doing well, I take it.
Yep, I'm working as a vet tech and going to school, so
So you're working as a vet tech. What are we going to school for?
to be a licensed vet tech.
Ah, fantastic.
Yeah. My mom says she
All right.
watches you all the time and she misses you, so.
Okay. Give my best, please. All
I
right.
will.
You take
Have a
care of
great day.
yourself.
You too.
All right. Court calls the case, people versus Davian Copelan.
There's no problem, Your Honor.
Davian Copelan, how much is that?
$3,300, and I apologize. He apparently was in Zoom earlier, but he is not.
Oh, he was?
Yeah.
Okay. And then I'll adjourn this out to my October 8th. Is it?
Yep.
October 8th, 2025, 9 a.m. Court calls the case of the people versus Jerel Davis.
Under Natalie Pate, with and on behalf of Mr. Davis, who is present via Zoom. Sir, can you please unmute and state your name for the court?
I think he's trying to unmute.
Okay, I'm here.
Okay, state your name.
Jerel Davis.
All right.
Thank you, Your Honors. I believe his balance is currently, Mr. Davis's balance is currently $370. He did make a $50 payment this morning, bringing his balance down to that number. I believe we'd be asking for adjournment of the show cause, but he stated to me he's trying to get this paid off in the next couple of months.
Okay. Is that right, sir?
Yes.
Okay. Why don't you give me my November date, 12th?
Yes.
I'll adjourn this matter to November 12th, 2025, 9 a.m. And I'm going to indicate defendant to pay balance.
Okay.
So get it paid off. All right?
All right, thank you.
Thank you.
Thanks, David.
Court calls case people versus Cerius Edwards.
Public Defender Natalie Pate, with and on behalf of Mr. Edwards, who should be present via Zoom.
Yes.
Awesome. Mr. Edwards, can you please state your name for the court?
Cerius Edwards.
All right.
Thank you, Your Honor. I did speak with Mr. Edwards regarding this. He's asking for a $25 per month payment. He stated to me that he currently has an FOC matter going on. However, he does provide for his kids full time. So I would be asking for that payment plan.
Is that right, sir?
Yes, sir.
All right. So when can you begin the 25 per month?
Probably next Friday when I get paid.
Okay. So here's what I'll do. Pay $25 per month beginning October 1 and then 25 per month until paid in full, okay?
All right.
We'll do it that way for right now. All right.
All right.
Thank you.
Yep, thank you.
Court calls case people versus Mohammed Farah.
Natalie Pate for Mr. Farha, who is not present, Your Honor. He states that he's currently on his way and was supposed to be here about around 1. He does have, so he has an outstanding warrant in a felony non-support case. He did attempt to take care of that, but was instructed that he needed to turn himself into the jail before he'd be arraigned on that. That being said, he was going to come here in person today to both deal with this, as well as then likely be taken into custody on the warrant or turn himself in. Obviously, he is not arrived from Flat Rock yet. I did advise him if this case is called, he was not there by then, I would tell him so, and that he should then just turn himself in on the FNS case.
Yeah, okay, so I think I followed you. He was coming down on, I have it for me, so he was coming down on his child support case to turn himself in.
Yes, but he was scheduled for a show cause in this misdemeanor case as well. So I told him to appear in person, that hopefully the arraignment could take place as well in the show cause, and then.
Right.
Yes.
Okay, so.
Not here yet, but he's on his way. So he says.
Okay, yeah, right, I got you. I'm just. Do you know, because it's a child support case, whether he was looking to oh my goodness. Okay, that's what he owes. Okay. So give me about 25% of 26,000.
65.
Okay, so that you know, I don't know if you would have apprised him of this. That would be the bond amount if I did the 25%.
Yes, Your Honor. Yes.
Does he know whether or not he's going to be able to pay that?
Last we spoke regarding that, it is my understanding, no, Your Honor. Unless something has changed in his circumstance, I don't anticipate he would be posting that bond.
Okay, so here's what I'll do. You're going to be around this afternoon, Miss Faye.
Yes.
Okay, so what I'll do is I'll pass, what time is it now?
It's 1 o'clock.
Okay, so it's just 1 o'clock I'm gonna pass both of these, and even if I finish these, we'll wait a little bit. So that then when he comes, since he was gonna try to take care of everything, maybe I can give a quicker PCC date. So that we could, if he's gonna be in. All right, so I'll pass those. Court does call the case People versus Sylvester Holman.
Public Defender Natalie Pate for Mr. Holman, Your Honor. I do not believe it's present. Does currently have a balance of $1,245. The phone number I had from previously is now disconnected. I do know that you appeared in person for this violation of probation hearing previously. I would ask for an additional funds for the record. I don't have an explanation as to the failure to appear for this hearing.
Bench warrant will issue bond 10,000, give it 10% privilege. That warrant will issue immediately. Court calls the case People versus Keshan Jurgensson.
Your Honor, this is a show cause for cost. He does not have counsel. He's not here.
This is show cause for funds cost balance is about
$2,175.
Jurgensen, not present. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000. I'll give it 10% privilege on that. Warrant will issue immediately. Court calls case People versus Anthony Lafredo.
The Public Defender Natalie Pate, present via Zoom.
He's not here.
Your Honor, I did send him the Zoom information from the voicemail. It's my understanding that the balance is $654. For the record, I request an adjournment.
Bench warrant will issue $7,500, 10% is the amount. That warrant will issue immediately. Just the first one. Court calls the case People versus Darian Roads.
The show cause for fines and costs, Your Honor, without counsel, there are $758.
That's 1357.
Yes, sir.
Darian Roads. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500, 10%. That warrant will issue immediately. Here, you can have it. Court does call the case People versus Gary Thomas.
Under Natalie Pink, Mr. Thomas, who may be present via Zoom. Sir, if you're present, can you please unmute and state your name for the court?
He's not in Zoom, Your Honor, but he's a family member waiting room.
A family member?
Yeah, said they're family.
Your Honor, this one, Miss was one of Mrs. Kearney's. She did send the Zoom information, but has not had an opportunity to discuss his balance with him. She did receive an email during the docket earlier from his email address. That seemed to think that he might be on the Zoom, but I don't know for sure.
Let him in. Let's. That's her. That's him. Okay. Court calls case People versus Gary Thomas.
Assistant Public Defender Natalie Pink, on behalf of Mr. Thomas. Mr. Thomas, can you please state your name for the court?
Gary Thomas.
Okay.
Your Honor, I believe we're here for show cause on unpaid fines and costs. I believe Ms. Kearney did reject Mr. Thomas. Has not had an opportunity to discuss with him his balance.
I think he owes 905.
Yes.
All right, Mr. Thomas, you owe $905. How are you gonna get that paid?
As soon as I just get out of jail, I only been out almost a month, so I'm still looking for work.
Okay, let's do this then, because I think you finally got out, right?
Yeah.
Okay, so I think I knew, and we adjourned it to the last time. I'm gonna adjourn you to November 12th, 2025, 9 a.m. I need some money paid. I need some money paid, or you gotta come to me with a plan on how we're getting this done.
Okay.
You hear me?
Yes, sir.
All right. Take care. Thank you. Okay. That's that. We'll wait on that. We'll check with you.
He did text me 1 minute ago.
Oh,
So I texted him, told him to come to the courtroom, the judge passed your case. Then he texted me 1 minute ago. I really apologize. 45 minutes ETA. 1 hour. So
I'll be here. Court does call the cases of People versus Mohammed Farah.
Assistant Public Defender Natalie Pate with on behalf of Mr. Farha, who stands to my right. Please state your name for the record, sir.
Mohammed Farha.
All right. Let's dispose of the issue regarding the misdemeanor, and I'll get to the felony.
Thank you, Your Honor. I believe the misdemeanor case was set for a show cause hearing for review for payments.
Yes.
Our plan was to ask for an adjournment of the show cause hearing, Your Honor. Mr. Farha is working currently with his brother-in-law and doing mechanic work, but he does not have, is unable to make payments on that case at this time. So we would ask for an adjournment of the show cause.
All right. I'll adjourn the show cause to November 12th, 2025. All right. On that one. Then, Mr. Farha, you are here on a felony complaint that has 2 charges to it. You understand that, sir?
2 charges?
Yeah, there are 2
Okay.
separate.
Yeah. Yeah, for child support, right? Yep.
Yes, sir. The complaint indicates that between the dates on count 1, between the dates of September 1st, 2023 and August 30th, 2024, that you did not pay child support for his children in an amount that stated in an order entered by the Washtenaw County Circuit Court. And that is in case number 2022-1933 DC. You understand the nature of that charge, sir?
Yes, sir.
That's a felony punishable by up to 4 years incarceration, a $2,000 fine plus court costs. You understand that?
Yes, yes, sir.
Also in that complaint, there is a count 2 alleging that between December 1st, 2024 and March 31st, 2025, that you did fail to pay support for your children in an amount or at a time as stated in an order entered by the Washtenaw County Circuit Court in that same file number. You understand that, sir?
Yes.
That is also a felony punishable by up to 4 years incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
This is a public defender case.
Thank you, Your Honor. Again, Assistant Public Defender Natalie Pate with and on behalf of Mr. Farha, we would waive any further formal reading of the complaint. My client stands mute to the charges. We would ask for a probable cause conference date, Your Honor, as well as to briefly address bond when appropriate.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. I'll set a probable cause conference for knowing that Mr. Farhar was trying to get down here. I would normally be setting this out to October, but what I'll do is, and I think we can certainly get the notice to the Attorney General's office. I'll set it earlier.
Thank you, Your Honor. I appreciate it.
For September 30th, 2025.
Thank you.
That's at 9.
Yes.
At 9 a.m. All right, Esteban.
Thank you, Your Honor. I do understand that given the nature of the charges, there is a statutory requirement for which a bond must be set. I'm asking that the court set the bond at the lowest amount possible by statute.
I'll first order, I'm going to order all standard conditions, including no assaultive behavior or possession of any weapons. You understand that?
Yes, Your Honor.
I'm also going to understand no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes, Your Honor.
I am also going to set the paperwork which was sent with the complaint alleges that the amount in arrears or what was owed on the account. I looked at it and it was $25,996.30, which in essence is about 26,000. And so I will set your bond. I cannot go lower than 25%.
Okay.
So I would be setting your bond in the amount of $6,500, cash only, and that will be payable on case 2022-1933 DC in the Washtenaw County Circuit Court.
Thank you, Your Honor.
All right. Anything further? Any questions?
No, Your Honor.
All right.
Thank you. I'm sorry about getting over here so late. So
your counsel, you can thank your counsel, was paid. She was letting me know that you were trying to get.
I appreciate
so
it.
we waited, and I appreciate you coming in and getting that taken care of. So hopefully we can get this resolved.
Thank you.
All right.
All right.
Thank you, sir.
All right.
Defendants remain.
Thank you very much, Your Honor. Thank you.
Thank you.